Every day, citizens around the country are faced with new dilemmas. Dilemmas that affect them profoundly. Whether it's injustice, discrimination, falling through the cracks, scandal and cronyism, balances of power, ethics, religious freedom, state versus citizens, and unfunded mandates, and the list goes on and on and on. Welcome to Spika. It's directed at those who have fallen through the cracks, and it gives them a voice. It's your turn to speak up, to stand up and fight back. Most likely at some point, you're either acquainted or directly involved with the New Hampshire court systems. Today's program is to take a look into the New Hampshire family courts, some of the abuses potentially that you may be aware of. As you know, I sit on the Redress of Grievance Committee in Concord as a state representative. And there seems to be a common thread that runs through all of the committee meetings. And that has to do with the rules of the courts and the process that some of the people are complaining about. The processes of injustice. Instead of getting justice, some of the people are claiming injustice and unfair practices by our judicial system. We're going to take a close look at that today and in a couple of other broadcasts as well. In 1978, the New Hampshire legislature, the voice of the people, gave its rulemaking authority to the court system, specifically to the Supreme Court Justice, where the Supreme Court Justice would be the administrator of rules for the entire court system. Part of that amendment that was granted in 1978, the last line, and such rules shall have the effect of law, which poses a problem. What happens when the laws are contrary to the rules of the court? What happens when a marital master causes an individual to use their entire life savings in a divorce hearing because of custody issues, which are contrary to law? What happens if you feel a judge made a rule that is unconstitutional? Have you ever tried to convince a judge otherwise, to change a rule? That's what this episode is going to begin to touch, begin to talk about. How do you change the rules of the courts if the legislature has no jurisdiction there? So let me start off with introducing my guest, Mr. Josh Youssef. Josh, I want to welcome you to the program.
Thanks for having me, Kevin.
All right, great. Well, we've been talking a lot, and the reason I brought you on board is because you're one of the petitioners.
I am.
As you know, I serve here on in the New Hampshire House on the Redress of Grievance, and your grievance came before our committee. And I'm beginning to see a common thread with a number of these redresses, and you happen to be number 26, which happens to be a special number for me, and we'll talk about that in a little bit. But one of the common threads is the way you're being processed through our judicial system, and I want to go over some of the things that maybe you're finding difficult. One of the things that you're finding is roadblocks, or that maybe you think things should change. So let's get started with the conversation.
Sure.
Tell us a little bit about yourself. Your name is?
My name's Josh Youssef.
Right.
I'm from Laconia. Born and raised, lived there nearly my whole life. And I was married. And I was divorced in 2006. And I have a great little boy. He's 8 years old now. And up until last weekend, I hadn't seen him in 13 months. I'd had no contact with him whatsoever.
Let me just stop you right there. You haven't seen your son in 13 months.
That's correct.
Did you commit a crime?
Never.
Are you accused of a crime?
At one point I was, but I was cleared.
Okay, so you were not prosecuted in this whole 13 months, there were no findings?
Absolutely
You're
not.
exonerated.
It was a false allegation.
Okay, which anybody could throw at you.
Correct.
Right. So if it's an unfounded and you did not do a crime, 13 months is a long time to be punished or to be kept away from your child. Let's continue.
Sure. Well, what happened was, in my matter, things were going great until January of 2009, when my ex-wife brought a petition to modify child support, to modify custody, and some other ancillary issues before the court. So she reopened the case, essentially. And then a guardian ad litem was appointed. A guardian ad litem is a representative of the child. They represent the child's interest. Presumably each parent will have their own attorney, and then the child, of course, is left in the middle with no representation.
I see.
So this guardian ad litem, which is appointed by the court, they're an officer of the court, they become an official of the court, if you will. They are charged with the duty of finding and compiling facts and expert data pertaining to each parent and the way the child and the parent interact with one another and what have you. Now, I'd just like to state that I had a wonderful, wonderful relationship with my son, right up until the very last time that I saw him on January 23rd of 2011.
Mm-hmm.
And over the course of the 13 months of absence from my son, I would have a nightly phone call with him, which I noticed was slowly deteriorating. And he was becoming more distant, he was becoming more disrespectful, he was becoming more belligerent towards me. And
now, can I just stop you right
certainly.
there? That's not because of the guardian ad litem, is it?
Not at this point, no.
Okay.
Although the guardian's participation throughout the entire case was very, very prejudiced against me. I just didn't feel like I was being listened to by anybody.
Did you have conversations with the guardian?
I had conversations with the guardian. She was rude, and she just treated me like a second-class citizen. I felt like there was no way that I could present my story to her that she was going to actually listen to what I had to tell her. It almost seemed to me as though she had already predetermined the outcome.
Kind of a hostile witness to it.
It seemed that way, and at the time I was represented by a very good attorney, and I didn't realize the machine that I was in. I had kind of been fed into a machine, and unfortunately I fell victim to many of the machine's barbs.
When you say machine, that automatically throws up a huge red flag for me, because it automatically says there's a process that's you just can't shake. Machines worry me, and so you filed a complaint with the Redress of Grievance, and because of
I did.
of this period of time where you've been separated from your child,
Correct.
having committed no crime.
Correct.
And you're finding all of a sudden you're not getting the right answers.
Correct.
And now you want to be heard.
I just want to be heard. That's all I want. And I want to be heard in front of an impartial, fair judge, marital master, tribunal, panel. I need fairness.
Excuse me.
I occupy multiple roles in my case. I am the litigant. I'm the father. I am the one that helps him with his homework. And I act differently in different roles.
Right.
Naturally, when you're representing yourself, which I found to be a real challenge in the family court, they look down on you. They don't listen to you. They don't follow the law. They follow each other.
And you can prove that.
I can prove that.
Now, just for the record, are you an attorney?
No, I'm not an attorney.
Are you a son of an attorney?
No, I'm not related to any attorneys.
I just want to clarify that.
Not at all.
Because listening to some of your testimony, it appears to me you've done your homework.
I've had to do my homework.
Yeah.
I've been dropped into the middle of the ocean not knowing how to swim.
Now, you signed a contract with the guardian ad litem.
I did.
You have to pay their bills, basically. I know that I believe it's $1,000 per case that a guardian ad litem is supposed to be paid.
Well, there's an administrative order number 17, which says that the maximum fees that can be charged are $1,000 without leave of the court. So that means that the court must approve of any increase in guardian ad litem fees. In my case, the fees totaled about $5,700, I believe, give or take a couple of $100. It's been a while since I've looked at the bill.
For the guardian ad litem.
Correct.
Now, do you have to, as a contractor, approve that increase as well? I mean, or is it completely at the hand of the discretion of the judge to say, you know what, you're going to pay some more, you need some more time. The guardian ad litem needs more time.
Well, that's a great question, because I was faced with that very proposition in front of several different judicial officials. I never had any say in the increase. I could object to the increase, the guardian's request to increase her fee ceiling, if you will. However, the fee increase request was always granted by the judge. It was a contract that I was coerced into. My hands were tied as far as the contract was concerned. Mm-hmm. So it was essentially a blank check for the guardian ad litem. And it almost seemed like there was a little bit of push-pull between the court and the guardian ad litem. And some references were made in various hearings that, the reputation of the guardian ad litem was never in question by the court and what have you. So it was clear that the court had worked with this individual at least in the past once or twice.
They have a history.
They have a history,
right,
which concerned me because any possible predispositions that the judicial officials may have are going to be represented by or reflected by their choice of a guardian,
right,
which I found to be the case in my
both,
matter.
Both parents are responsible for the fees of the guardian in most cases, from what I understand.
Well, the way the orders, the administrative orders worded, the court can appropriate the responsibility in proportion to its discretion, and usually it's relative to one party's income versus the other, what the expected cost will be, and a party's ability to pay.
If I recall, in your case, one of the stickler points for us is if you didn't sign that contract to take on this guardian ad litem, you wouldn't see your kid.
Basically, that is correct. There is some procedural history that's important to note. The false allegation was propagated against me, not by my ex-wife, surprisingly, but it was propagated by the guardian ad litem herself. Now, she later made admissions on the stand, under oath, that the very nature of the allegations she made were not in line with the actual allegation that she made. So it begs the question, why did you go to DCYF if you never thought there was abuse and neglect going on? Because my understanding is DCYF is the abuse and neglect investigation and enforcement arm of the state of New Hampshire.
Right.
So if she later said that she never thought that there was abuse and neglect, then why did you go to this agency in the first place?
My question is, why did the judge keep her if that was unfounded?
I went to the ends of the earth, north, south, east, west, up and down, to try to get that guardian's testimony, her reports stricken from the record,
right,
and the court refused, absolutely refused.
Let's talk a little bit about DCYF and Title 4D money.
Sure.
A lot of people will be surprised to note that there's a program, a lot of programs are tied to some Title 4D money, and I believe it is the DCYF. Correct me if I'm wrong, please. Sure. I don't want to step out of line. But the Marital Master program and DCYF, a number of these things trigger off or red flag federal money.
Correct.
So
it's a reimbursement, actually.
It's a reimbursement, I believe up to 60%.
I don't know the exact number,
right,
but the governor's office
won't have that as a
has a record of that.
Right. So in other words, if DCYF gets involved with the case, whether founded or unfounded, there's federal money involved.
That's correct.
And from what I understand, judges, the Marital Masters, I should say, which are subcontractors of the court system, they're funded by federal money as well under Title 4D money.
That's correct. So they actually have an incentive to protract and prolong cases. See, it's very complicated, but
I've heard that somewhere.
But, when people tell me that it's complicated, I welcome the opportunity to parse the complication out.
Right.
Let's get down to the definition of words if we need to. But the reason why it's so complicated is because of an indoctrination, a social culture that has evolved over time. And it never used to be this way in American jurisprudence. There's always been a presumption that both parents will be involved in the raising and the rearing of a child. But that all changed toward the second half of the 20th century, so from, say, the early 60s on. And it really has grown deep roots even in the 80s and the 90s and the 2000s, and especially right up until today. Mm-hmm. There is no presumption, or let's put it this way. We found in researching hundreds of cases that it is very much not the pattern of the New Hampshire judicial branch to treat a divorced family and the child or children that are in the middle of that as though they need both parents. And that's a very, very disturbing proposition, because what they've done, evidently, I'm not saying this in every case because there are tens of thousands of cases, right, but in the sample that we've been studying, and we've studied them qualitatively and quantitatively, it appears as though the courts are removing children from fit parents and denying the litigants, the fit parents, due process of law in removing their children. Now, what do I mean by all that mumbo jumbo? Yeah. What I mean by that is the New Hampshire Supreme Court came out with an amazing decision in, I think it was January 28th of 2011, and it was called In Re Guardianship of Rena D. Now, Rena is a child, and because abuse and neglect cases are sealed, they don't give last names and what have you. You can still read the decision. All the last names are redacted out. But in that decision, the Supreme Court of New Hampshire found that the definition of a fit parent is a parent that has not been adjudicated or found by an agency or a court of law to be unfit. It follows in the line of jurisprudence dating back to the founding fathers of this country, that you're innocent until you're proven guilty. Right. Now, what's very important to discuss regarding this Rena D case is that the New Hampshire Supreme Court follows very, very closely in the United States Federal Supreme Court a decision that was handed down 12 years ago, and it's called Troxel versus Granville. Now, in Troxel versus Granville, the U.S. Supreme Court held that there is a presumption that fit parents will act in the best interests of their children. And then it goes on to say, normally there's no reason for the state to inject itself into the private realm of the family because the state can't provide what the parents, what the family unit can provide.
Well, that seems like a common sense statement.
It would seem that way. Right. But what the state of New Hampshire has evidently been doing, and they did it to me, so I can speak for myself, and I'm not going to mention names right now, but I could give you a list of 25 to 50 individuals that I have worked and spoken very regularly and closely with who have experienced the same problem, not in just one family court. It's not isolated to a particular county or courthouse. These are cases that are spread all over.
The machine.
The machine.
We're going to be right back, and we're going to talk a little bit more about this machine and the problems that we're having, maybe in a little bit more detail. So we'll be right back. Was your lawyer aware that you spent $9,000 on a guardian ad litem, and may I ask you what the fee for the lawyer was by the time you're done the process, or are you still?
She knew what was charged. I didn't pay the whole $9,000. On that paper, it does say how much I paid her. I think I paid her $8,000 something. My lawyer was aware of it. Every time they filed the motion to exceed, we asked for it not to succeed. And I have records at home what I paid my lawyer, but I'm not exactly sure how much. All I know is my life savings were pretty much used up.
Well, that was an interesting clip about the guardian items and the cost. But before we get into that, let's focus again on the fit parent aspect. You were interrupted a little bit about that.
No, that's fine. That's fine.
Let's talk about that.
Well, there are two real categories of parents. There are fit parents and there are unfit parents. Now, the way you deal with an unfit parent is there are two primary ways that the legislature has provided to deal with unfit parents. One of them is in an abuse and neglect proceeding, and another method is in a termination of parental rights proceeding. Now, the way you deal with a fit parent is you deal with them according to RSA 461A, which is the domestic relations statute. But like we found in, or like the New Hampshire Supreme Court in following the U.S. Supreme Court found that there's a presumption that fit parents will act in the best interest of their child. What is the reason, I ask rhetorically, that a fit parent would have his parental rights effectively terminated with no showing of abuse and neglect?
What do you mean by effectively?
Okay, that's a great question because I was trying to emphasize that word. An effective termination of parental rights is essentially the same as having your parental rights stripped in an abuse and neglect or a termination of parental rights proceeding, but it doesn't have that label. You don't walk around with a black cloud of termination of parental rights hanging over your head, but when you don't have the right to access or control or participate in the education or religious training or medical treatment of your child or children, well, to have that right removed from you is a termination of your rights with no real reason if you're a fit parent. And then compound that with the fact that if you have your rights taken away and then you have your visitation taken away,
in effect,
what do you have left?
Right.
What do you have left?
Well, that brings up another case that was before you, grievance number 11.
Dr. Vandenberg.
Dr. Vandenberg.
Yeah.
Now we have all walks of life that come into our committee. Some cases are founded, some are not founded.
Yeah.
In Dr. Vandenberg's case, he broke no law.
That's right.
His child has been taken away from him. I believe it's 3 years.
3 years.
Which I'm trying to process in my mind. How can the court justify taking away a child for 3 years from a parent having committed no crime?
Well,
and he's a doctor.
It's a great question. I wish somebody had the answer. I can tell you what he was accused of. He was accused of practicing his Christian faith with his daughter, praying, reading the Bible, and taking her to church. And it would appear, and I'm not here to speak about religion at all, I'm here to speak about my personal experience and my observations in family court, but it would appear to me that the free expression of one's faith is protected by the state and federal constitutions.
I believe even in New Hampshire law, it's RSA 461A11.
Well, actually, 461A11 would actually govern that's the standard for modifying a parenting plan.
Okay.
So this is a good opportunity to talk about that, because in 2009, the New Hampshire Supreme Court determined that courts can't just modify parenting plans. It's disruptive to children, it's disruptive to families, it's not in keeping with the state's statement of purpose that children do best when they have stable and ongoing relationships with both parents.
Right.
So that case was called Muchmore versus Jaycox. And what happened was the Supreme Court said, you can't just modify a parenting plan. You need to choose one of the statutorily enumerated grounds to modify the parenting plan. And those grounds are enumerated and found in RSA 461A11. Most commonly, the courts will use paragraph 1, subparagraph A, B, C, D, E, and now F. So we're finding in many, many, many cases that we have a very serious and pervasive epidemic that's flowing through the family courts right now.
When a judge operates outside those perimeters, isn't that breaking the law?
Well, that's a very complicated discussion regarding absolute judicial immunity. Interestingly enough, a judge can't break the law for all intents and purposes. They're protected from all litigation.
Does he violate your rights?
Absolutely. It happens all the time, every day.
So my question in the opening of the show, what does a person do when a court, the judge, marital master, guardian ad litem, DCYF, anybody that is related to the family law, what happens when they violate your rights? What recourse do you have?
Well, thankfully, we have more than one branch of government. It would seem when you're in the crosshairs of the family division that there's only one branch of government. But I was, in reading through the Constitution of New Hampshire, it was highlighted that I have the ability to petition the state of New Hampshire, the legislative body, to the Committee for Redress of Grievances. What that allows me to do is seek out my representative or any other representative of the state to have coffee with them and say, "Dear Representative Smith, I'm having a real problem with this agency of the state." It's not just for family law matters. It's for an aggrieved citizen or a member of the constituency, if you will, that has been aggrieved by an agency or a department of the state. In my case, it was the New Hampshire Judicial Branch, Family Division. So I sought out my local rep, and I told him what was going on.
So I do want to talk just a little bit about that real quickly. Doesn't that open up a Pandora's box? I mean, nobody wants to pay taxes. Nobody wants to pay their water bill. They feel like the state's aggrieving. We want to narrow a little bit more focused on,
sure.
When somebody is aggrieved by the state, it's because the state is acting outside its parameters given to it via the people.
Correct. Through
the legislature.
That's absolutely correct.
With the foundation of the New Hampshire and federal Constitution.
That's correct.
Okay.
What that means, essentially, is that we have a representative form of government. It's government of, by, and for the people. And so the people choose the reps. The reps bring law or proposed law to the body, and it goes through an entire process where it either becomes law or it doesn't become law. But when officers or members of agencies in other departments of the state government violate the RSAs and the laws that the legislature creates, where else do you turn? But most difficult is, where do you turn when the very branch of government that is charged with interpreting legislative intent, the judiciary, the courts, when they violate your rights and when they deprive you of due process? Where do you turn? Well, thankfully, you can turn right back to the legislature, and you can say, hey, these people over here aren't following your laws, and I'm being injured by them.
But Josh, those people over there are saying, listen, you have a right to appeal.
Okay, this is the circular reasoning fallacy. The problem is that we're trapped inside of a circle where there's no entry point and there's no exit point. And so the way that the appeal process works in New Hampshire, there is no court of appeal between the trial court and the Supreme Court. Now, that's not always true, but in the case of family law matters are appealed directly to the Supreme Court. But the Supreme Court has two categories of appeals: mandatory appeals, which they must accept, and discretionary appeals. Now, those two categories are parsed out in the Supreme Court rules, which cases they are allowed to categorize as mandatory versus discretionary. And the viewers and the listeners of this program can turn to the Supreme Court Rule number 3. Rule number 3 articulates that all appeals are mandatory with the following exceptions. And then it goes on to list all the exceptions. There are certain things that just are not mandatory appeals. They don't automatically get accepted. And one of those is a person who is unmarried that is under final orders on parenting may not automatically be granted a mandatory appeal. The key word in that is unmarried.
Unmarried. So let me read a statute to you real quick. New Hampshire law.
Yes.
RSA 341, A1, explicitly bars discrimination based on familiar status. That's what we're talking about here.
Yes.
Quote, the general court hereby finds and declares the practices of discrimination against any of its inhabitants because of age, sex, race, creed, color, marital status, familiar status, physical, mental disability, or national origins are a matter of state concern, that such discrimination not only threatens the right of proper privileges of its inhabitants, but menaces the institutions and foundations of a free, democratic state and threatens the peace and order, health and safety, and general welfare of the state and of its inhabitants. We're looking at the familiar status specifically, and for some reason, Rule 3.9 segregates a certain class of people and says, listen, you don't have that mandatory right of appeal.
That's right.
In New Hampshire court. Well, wait a second, Your Honor. I have a constitutional right here. Which brings me to my next question, and it's one of the questions that keeps me up at night over and over and over again. In 1978,
yes,
the New Hampshire legislature gave the people's voice, gave the people's rights, gave it over to the courts by surrendering all rulemaking ability to the Supreme Court justice.
That's correct.
So when it comes to court rules, the administrative rules of the court, instead of it coming from the legislature, and I want to preface that by saying whenever I mean the legislature, I mean the people's voice. The legislature is your representative. It's the person who says, this is what the people want for law.
That's correct.
This is how things need to be run. And there are plenty of checks and balances. There are at least 400 of us up there.
Oh, yeah. There's a lot of infighting.
And in the process, then we have a Senate that we have to deal with that either manipulates some things. And it goes through its process. By the time it's been done, that bill, that law, has been vetted by the people.
Very well refined.
And for the people.
That's right.
Sent across the way, and then has to be enforced by the judicial branch.
That's right.
So when I say the legislature, the representatives, in 1978 said, you know what, we don't want this responsibility anymore. So they made an amendment, and they said, we're going to transfer the people's rights over to a judge.
The Supreme Court Chief Justice. Article 73A.
Second part, Article 73A, correct. And the Supreme Court Justice shall be in charge of the administrating over the courts and shall be in charge of making the rules.
And all rules so promulgated shall have, and I quote, the full force and effect of law.
Now my question is, and the reason I'm bringing this up now because of your timely statement, when you want to go sit down and have a cup of coffee with your state representative and say, listen, I got a problem.
Yeah.
You can do that, and it's not going to cost you your life savings.
Correct. Which is a far cry from what happens in the judiciary, I might add.
And, well, in addition to that, when was the last time a person has been able to sit down with a judge and say, hey, look, Judge, Your Honor, can we change this rule?
You can actually be charged with a felony called influence. I believe it's called influence of a judge or official influence. And what it means is that you're having ex parte communication, attempting to influence a judge. And I believe it's governed by RSA 460 or somewhere thereabout. Don't quote me on that. You're not allowed to communicate with judges. If you're at the grocery store and you see your judge, we live in a small state, small towns, you better run the other direction if you see your judge.
If you see your judge, but you can talk to a judge in passing.
Any judge that's ever dealt with your case, you can't talk to them in a fashion that would be construed as attempting to influence them.
Oh, I see. All right. So in other words,
but if the judge doesn't like you, then he's going to construe it as being influential.
So if the point of the matter being is if you want the judge to change his mind outside of the court situation, you put yourself in somewhat of a jeopardy.
Correct.
But if you want to change a rule for the courts with a representative, you can't do that anymore. Unfortunately not. Because of the rulemaking authority being passed over. Now, we've had 30 years of approximately of this, maybe, was it 30 years?
34.
34 years. And people are just hearing about this now because of this show. But what I'm finding is over the years there have been many attempts to try to overturn this, and it's not passed the legislature.
It's a disturbing problem because essentially in 1978, I was only 2. My voice couldn't register a 2-year-old's voice. But essentially they gave away the people's voice so they could no longer participate in the rulemaking process within the court.
Let's talk about one of the rules before we go any further.
Sure.
We've had petition number 5. There was the Johnson case, and he's actually one of the first ones to bring up this to mind. There is petition number 11. There's petition number 31. There's a number of petitions where people have actually brought evidence to the court. I'm trying to think of the word, affidavits.
Sure.
So you go against the affidavit, you're found guilty.
Oh, it's a sworn statement.
It's a sworn statement.
It's made under the penalties of perjury.
Whether it's that or DCYF or other agencies, even guardian ad litems, where exculpatory evidences have been brought before judges, and because of Rule 1.2, that's your segue.
You mean waiver of rules?
Waiver of rules. What is waiver of rules?
Waiver of rules, and I'll do my best to summarize what it says. For good cause shown, the court may waive any one of the rules.
But, Your Honor, I just spent $35,000 with this attorney to clear my name and get my kid back. I've done no wrong. I've broken no laws. Mm-hmm. I want to see my kid. Yeah. Here's the evidence.
It doesn't matter.
And if the judge doesn't like you, and I'm being very visceral about that, and I'm being very, very plain about that. If he doesn't like you, or he doesn't like your case, or it's not convenient for the court, or in the interest of the court, or in the interest of the children, which we know children do get abused.
Of course they do.
And we're not going to even go there right now. But if the judge deems it not admissible because of Rule 1.2,
he waives it on his own discretion. And you know what's so disturbing about that is that in my case, the guardian ad litem said, well, just because DCYF said it was unfounded does not mean that it didn't happen.
How do you fight against that?
You can't. It's impossible. Because DCYF is the very agency that's charged with the investigation of these matters. Their word should be the word.
Yeah, I have difficulties with that one right
However,
there.
Rule 1.2 can undo a lot of doing.
Right. There's an issue, we recently passed it in the House, but it had to do with House Bill 415, with parents having a right to know and face their accusers.
Sure.
We're finding that there's cases where there's information that is put in these sealed envelopes, whether it's with DCYF or whether it's with the guardian ad litem. The judge gets to see it. The child's taken away from a parent. However, the parent has no access to those files.
Sure. That is an absolute denial of a constituent or inhabitant of New Hampshire's due process right to be able to produce all proofs that are favorable in his defense.
Well, one of the arguments was, well, there's third-party evidence in some of these sealed documents, and if we have the third party making testimony in these documents, well, you could, it could be medical records, it could be anything, but you could injure that third party. However, if the person did not commit a crime, why are the children being taken away from them? And if they did commit a crime, then why aren't they being prosecuted?
There's a lot of secrets being held, it would appear.
No conspiracies here.
No conspiracies. It would appear that there are things that certain people are trying to be protected from. And I would ask the same question, what is the third party hiding?
Right. And why is it...
why is it such a big deal?
If somebody... Well, we had the DCYF in one of our committees, and they were testifying, and his answer was, and you keep saying this word, and it keeps troubling me, because his answer was, well, it's complicated. Well, Mr. DCYF, hang on. I don't want to hear that if my child is taken away from me. I want to know what is going on. What evidence do you have? And if that answer complication is not going to fly with me, either that person is guilty or they're not guilty. If you have evidence, prosecute. If somebody's hurting a kid and they're abusing that child, we saw something today, it was horrible on television, I don't even want to get into it. That person needs to be in jail for the rest of their life.
I couldn't agree more.
But if they didn't, then you are actually harming that parent by keeping that child from them.
That's correct, and that is reiterated in RSA 461A. The state's statement of purpose is that children do best when they have stable and ongoing relationships, and contact is the word they use, with both parents. Now, some of these things do get complicated, but they're not complicated by anybody but the court themselves. It's the machine I was talking about. It's a familiar group of individuals that all practice in the same realm over time. It's a judge or a marital master that works with a particular group of guardians ad litem, guardian ad litems, and therapists and counselors and accountants and reunification specialists, et cetera, et cetera. And so it only becomes complicated by the process. And what's very important, I don't mean to be trite, but it's cronyism is what it is. It's a group of people who are satisfied with sub-mediocre performance. They are not held to a high standard. And it would appear that the special training that RSA 490-D claims that marital masters and marital judges are supposed to be certified with, it would appear that they are just not trained to reduce complication. They only know how to complicate.
I want to talk a little bit, while we still have some time, about the docking and scheduling, and we'll probably have to have it in another, if you'd like to come back on the show. But and I want to end with this because the machine, it always, again, it brings up a red flag with me, but this whole idea of docketing and scheduling motions and petitions with the courts has a dark cloud over that as well.
Oh, yes, it does.
Real briefly, if you don't mind talking a little bit about that. You have a case.
The brief overview is that when you bring a complaint, the complaint is supposed to be docketed. It's assigned a docket number. The docket number usually reveals what court it's in, what numeric ordinal, whether it's the 1st, 2nd, 3rd, 4th, 5th, 10th, 100th of the year 2011, so on and so forth. Now, when the complaint is brought, the complaint can be countered by, or can be defended by an objection or an answer or a counterclaim, and then when that document's filed, it gets stamped.
Right.
When it's received by the court. When it's received by the court, it assumes a docket number, or not a docket number, a document number. So that'll be document number 2. Then somebody files a response to that. That becomes document number 3. But what we're finding in researching cases, and it's happening all over the state. I can't say it's happening in every courthouse. I haven't been to every courthouse, but it's happening in a wide-angle view of the courts, is that documents are being postmarked on a certain date, and they're not being stamped in a timely fashion. And what that means, or what it would seem to evidence, is that if that thing is just thrown on the table and, oh, we've got to get the Smith document stamped, what happens if 2 days goes by? And let's say the opponent files some sort of a document that may have crossed in the mail. But he didn't file it until 2 days after Smith filed his. That would mean that there's an improper numbering. We're also finding, and I can personally attest to this, in one particular case, I noticed vast amounts of whiteout over the document numbers. Document number 421, 422, 423. Then we skip 2 or 3, 429. They all have whiteout on them. Now, what does that mean? And they've been renumbered. So what does that mean? It means that if a document was received and stamped on a certain day, then an objection was filed to that document, it could be renumbered so that the document, the objection, was not filed in a timely fashion so as to prejudice the person who filed the objection.
What about the cherry picking?
Well, that's something that we affectionately refer to as the preferred litigant versus the despised litigant.
And the reason I brought that up, in the Vandenberg case, and it just keeps hitting me, this is so well documented, that there are preferred, like you said, litigants and unpreferred. It's kind of like a blacklist.
It certainly is.
So in this particular petition, there was the claim that there was an appointed guardian at Litem that was not legal.
That's right.
And not only did, in the Vandenberg case, was there a faulty appointment, it went retroactive, which ended up costing him $32,000 for the guardian at Litem.
Oh, yeah.
Which wasn't split. He had to pay the whole amount.
That's right. He was faced with incarceration.
And when he brought his complaint to the court, it put him on the naughty list.
He was on the naughty list. And I've had an opportunity to interview Dr. Vandenberg personally, right. And I've also had the opportunity to appear on a radio show with him as well. Mm-hmm. And Dr. Vandenberg is an intelligent fellow, very intelligent, and he is a soldier of justice. When he sees that an official in government is not complying with the law, he seems to speak up. What's wrong with that? But what we have is such a closed circuit of officials that it upsets everybody and everything inside that circuit when some Lone Ranger comes walking in, challenging the authority of a particular judicial officer.
Based on law.
Based on law. This is not an angry litigant. I'd like to restate, this is not about being angry.
Right.
This is not about being a mad dad. That's what a lot of people, my guardian ad litem, like to refer to me as just a mad dad. I'm mad, but I'm not a mad dad. I'm actually a very happy dad when I have my child. The problem is that we have a reason to be mad. These officials are breaking the law and causing great destruction and prejudice to us. It is like we live in a judicial tyranny. It is untenable. It is absolutely ridiculous that in the 21st century in America that we have to live with this kind of oppression.
Josh, if people want to get in touch with you, do you have a website?
Well, I'm a contributor to a website that has multiple different contributors, and it's called judicialchildabuse.com. Occasionally, I'll contribute an article or a video or something to this website. And I like to make particular note that judicial child abuse does not focus on, we're not a father's group, we're not a mother's group, we're not a grandparents' group. We are a people's rights group. We're finding that children are being abused by the judicial system, and therefore we are attempting to raise awareness on this topic and to stop judicial child abuse. They can email the website at judicialchildabuse@gmail.com. Again, judicialchildabuse@gmail.com or www.judicialchildabuse.com.
Now, you're going to be having a TV show up in the Laconia area?
I am. It's going to be called Following the Case.
Following the Case. Very good.
We will be selecting some particularly noteworthy cases from the New Hampshire Judiciary, not just the Family Division, but we'll be spending a lot of time on the Family Division because it is just so infested with corruption that we're going to be choosing cases and following them and doing exposés and tearing apart the court orders and the pleadings just to see exactly whether these officials are following the law or not.
Well, I want to thank you for coming on the show. Thank you for taking the time. We probably will follow up with a couple of more of these, and we'd love to have you back.
Thank you.
With maybe Dr. Vandenberg. I guess the Haas case will be coming up very shortly.
Yes, it will.
Mr. Nick Haas, and apparently the feds might be getting involved with this as well.
That's the word.
Right.
That's the word.
So until we meet again, I want to thank you. And
thanks for having me.
Appreciate it. Okay. Well, thank you for joining us. And until our next episode, please stay tuned and give us a little more time to do some more investigating. All right. I want to thank my guest, Josh Youssef, for showing up here and just kind of having a conversation about some of his redress issues. We look forward to having some more conversation with other people as well. And we want to give a fair and balanced, if you will, approach to the issue. Coming up soon will be a piece of legislation that I, as a representative, feel is good for the state of New Hampshire. I believe that in 1978, the legislature gave your rights away and put them in the hands of a judge. The legislature is your voice. And when your voice is put in the hands of a judge, you have no recourse. CACR 26 is a constitutional amendment which will be coming before the House for a vote. I'm asking you, call your state representatives. Tell them to repeal second part, Article 73A, by voting for CACR 26. You know, if a state rep or if the legislature makes a bad law, you have recourse. You can call them up and say, this is a bad law. We need to change it. But if a judge makes a bad rule, such as waiver of rules or familiar status cannot be appealed to the Supreme Court, you have no way of getting justice. Thanks for tuning in. And until we meet again, God bless. Every day, citizens around the country are faced with new dilemmas. Dilemmas that affect them profoundly. Whether it's injustice, discrimination, falling through the cracks, scandals and cronyism, balances of power, ethics, religious freedom, state versus citizens, and unfunded mandates, and the list goes on and on and on. Welcome to Spika. It's directed at those who have fallen through the cracks, and it gives them a voice. It's your turn to speak up, to stand up and fight back.